Welcome to the Heartland Town Hall. My name is Martha Farrell, and today we're going to discuss the constitutional amendment that is on our Kansas ballot in August. It calls for electing our Kansas Supreme Court justices by popular vote, rather than using the merit-based process that we've had in place for years, 70 years, in fact. Our guests are Micah Kubic and District Judge Trish Rose. Micah is executive director of the ACLU of Kansas, and he's also chairing a group called Kansas United for Impartial Courts. Trish has been an elected district court judge in Hutchinson and Reno County for almost 16 years. Here to start the conversation is my co-host on the Heartland Town Hall, Dave Kendall.
Thank you, Martha, and thank you guys for joining us today. We're going to get right to it and try to do this as succinctly as we can. So, Micah, I know you've been doing a lot of presentations on this subject. Can you just give us a quick synopsis of what this amendment is about?
Sure. So this amendment is about changing the system that we have had here in Kansas for 70 plus years, a merit-based system for selecting Supreme Court justices. The system we have now is one where a panel of folks, some lawyers, some non-lawyers, some community members, assess potential applicants for the Supreme Court. They send some names to the governor picks somebody, and then the voters themselves get to weigh in through a retention election about whether to keep that justice or not. We have that system because it is designed to insulate the justices from politics, to insulate the court from politics, and make the court fair and impartial. And so what this amendment does is change that and instead have partisan, statewide, direct elections for Supreme Court. My concern about that is that all of this sounds like it's about a sort of technical civics change as the sort of thing that doesn't really get people riled up, kind of sounds like a sleepy little change, really, except when you think about the context behind it, which is that the folks who brought us this amendment, the folks who authored it, like Chris Kobach and Ty Masterson in the state legislature, have said that the reason that they want this change is because they don't like that the court is fair and impartial, and they especially don't like the rulings that the court has handed down. They don't like that sometimes the court has ruled against them. Our court in Kansas has been fair and impartial. It has handed down rulings that I agree with. It has handed down rulings that I disagree with. But in every case, it has done so based on a fair and impartial interpretation of the law. And what the folks behind this amendment want is to dispense with that and instead have these partisan elections that really will be bought and paid for by billionaire political donors from out of state. That's what we've seen in statewide Supreme Court elections elsewhere. Judges become politicians rather than judges. And that means that their decisions become political rather than based on the law. I think that's a big problem for Kansans. I think that's a big problem for our rights, which have been protected by this fair and impartial court. And I think it's a bad deal for Kansans overall to have judges become politicians.
So, Trish, you being on the court yourself, not the Supreme Court, but a district court, you have some thoughts about, from your perspective, what this entails. Could you talk about that?
Well, I sure can talk about what I think is important as far as encouraging understanding of this issue, because frankly, up until now in my judicial career, which is almost 50 years, I have never known the courts to be so much at the forefront of our discussions about an upcoming election. And I am an elected judge. So I want to clarify why electing district judges may be considered to be different than the vote that we have coming up August 4 for our Supreme Court. And this is little known by many people. Most people could tell you how their district judges are appointed or elected, or at least may be a little bit aware of that. In our district, the 27th Judicial District, which is comprised of Reno County, In Western Kansas, the districts are more multi-county because of population, but we are Reno County. We appointed our judges until the late 70s. And then we joined by virtue of a campaign started by one of our sitting district judges, actually, at the time. We switched by vote. The voters chose to move to electing district judges. We are one of 14 districts who elect, or which elect. 17 districts do use the merit appointment method for district judges. So almost evenly divided of the 31 judicial districts in Kansas. So I'm in Reno County. I filed for election. I ran in a election. The elections are partisan, meaning you file as a member of a party or an independent. And the difference between the district court and the Supreme Court is vast. Serving as a district judge in Kansas, just for example, my week consisted of mostly criminal hearings, sentencings. I didn't have a jury trial this week, but I will next week and often do. My decisions relate to crimes that are committed within the jurisdiction, sentencing those individuals, also family law issues. That's part of my assignment. Contrast that with the Supreme Court of Kansas. The Supreme Court makes rulings on any constitutional issue, whether it's state or federal. They have original jurisdiction of all redistricting efforts, and they have the ultimate jurisdiction over every decision I and every single district judge in the state makes. So with that, I'll let you jump in now with questions, Dave.
Well, you mentioned Micah, Chris Kubic as being one person that was explicit about what the intent was with this. There's another group, the Americans for Prosperity, is supporting this, and what is it, Kansas Chamber of Commerce? Are there other organizations advocating for the yes vote?
Yes, they have strong support from Americans for Prosperity, as you mentioned, Kansans for Life, that is the primary anti-abortion group in Kansas, Kansas Family Voice, another group that is strongly anti-abortion and very conservative on LGBT issues and voting rights issues. So I think it is very clear from the individuals and the organizations who are pushing this amendment that their reason behind it is not some sort of a grand philosophical debate about the optimal way of selecting a Supreme Court. It is instead very clearly that they want our court to produce different outcomes than it has. And more importantly, they want to guarantee future outcomes. And that is why they want to change the members of the court, because they don't actually want judges who are accountable to their community in the way that Judge Rose was describing. They don't want folks who are actually vetted by folks from the community. They don't really want folks who have those sorts of deep ties. What they want are justices who will single-mindedly pursue the agenda that they want and who will allow the most extremist impulses to go unrestrained. Again, I don't think the state Supreme Court is perfect by any means. There are decisions they have handed down that I disagree with, as there are with any judge. That's what happens in the real world. You meet people, you encounter people who you agree with, and some you disagree with. What you don't do in those situations, though, is expect the rest of the world to rearrange itself to meet your preferences every single time. And here, what we know is that there is a very real difference between district court elections, court of appeals elections that happen in some states versus the Supreme Court. The thing that we have seen around the country is that the Supreme Court races are the ones that attract the hundreds of millions of dollars of outside investment. And that is precisely because they are weighing in on the sorts of issues that the judge described, right? The billionaire donors from out of state who want to drive the country in a particular direction, they want to influence the constitutional jurisprudence that a state has. And so that's why they are willing to put, as they did in Wisconsin, $100 million into one single state Supreme Court race. That's not because it's not because Elon Musk, who spent tens of millions there, just suddenly decided that he was very interested in what happens in the Badger State. He doesn't have a home there. It's not like he suddenly got interested in the local zoning laws in Wisconsin. No. He wanted to influence the overall constitutional jurisprudence there and wants to do that all around the country. And so that's why you absolutely should look at the groups who are supporting this, because it tells you what is behind this push. It is not simply a civics discussion, right? It is not simply about an optimal system. It is designed to produce a certain outcome.
I'd like to explore the process that we currently have. I've been seeing ads for months. I mean, at least 6 months, I've been seeing lots of ads from the yes side saying that we always get better outcomes when the people have a right to vote on it. And so could one of you please talk about the current system and how that produces better judges than the public might be aware of?
Well, I might just jump in and say, hopefully this is responsive, Martha, but as a judge, I am to make decisions based on the law and the facts, and that's all. Not on what might make me popular, what might be something that someone who provided me financial support, although I didn't seek and didn't receive any financial support, but some district judges do, might come to me and advocate as a position that he or she is asking me to take. My decisions have to be based only on the law and the facts. That is my judicial obligation under the Code of Judicial Conduct. And arguably, switching to elections makes that less likely, or at least puts it to the point where there's a possibility that decisions not be based on only law and fact.
Well, in addition to that, some judges or some people, attorneys, are more educated about the Constitution than others. So we'd be looking for smart people, right?
There was another thing that they came off too, not only smart people, but informed people that know something about people's qualifications. And one of the things that I noticed, critique was that this committee that comes up with 3 nominees for the governor to select in the current system is primarily majority lawyers. And so that is put off as something that's not desirable, that you need to trust Kansans. So how do you respond to that, Micah, the idea that we need to trust Kansans and not attorneys or lawyers?
So I do think the current system does trust Kansans because it gives voters the opportunity to weigh in on justices through the retention elections. This narrative that the people, the electorate, is excluded from the system is just flat out false. It is wrong, wrongity, wrong, because voters absolutely do get to weigh in through the retention elections and decide whether they want to keep the justices or fire them. And I think beyond that, it is important to note that the system we have really gives us the best of both worlds in that respect. That is why it is the envy of the nation, because it allows justices to be vetted, to be assessed based on whether they know something about the law, whether they know something about the Constitution, whether they have a judicial temperament, and it gives people the opportunity to weigh in as well.
I'm afraid we've lost Trish. One thing I wanted to, well, this could be a long answer and you don't have to make it long, Micah, but the current system was established by constitutional amendment by the voters of Kansas, right?
That's right. So we have the system we have precisely because voters already figured out what was wrong, the opportunity for corruption, the opportunity for hijinks in the system that we have. So we used to have partisan elections. There was a giant scandal. Kansas is renowned throughout the country for having relatively clean politics. It's not a place where scandal and corruption happens a lot. But there's one time in the 1950s is the biggest glaring exception to that, where there was a corruption scandal, where a outgoing governor corruptly got himself appointed to the state Supreme Court. As a result, the voters said, we don't want our court corrupted by politics. We don't want outside influences. We don't want any of that. Instead, we want to create a system that will uplift fair and impartial courts, that will insulate the justices from politics and give the voters better outcomes. So they immediately adopted this constitutional amendment. I think the scandal happened that the very next general election, the voters overwhelmingly said, we want fair and impartial courts, not politicized ones.
The other question I have for you, Trish this morning forwarded me the wording of the constitutional amendment. And my goodness, it's complicated. What do you have to say about that?
So it is complicated. The language is complicated. It's hard to follow, as laws and statutes often are. And I think that there will be a number of folks who need to hear from venues like this, from forums like this ahead of time, to understand not only what is on the ballot, but more importantly, the impact. Because frankly, the language on the ballot is the least misleading thing about this. The language on the ballot, although it's complicated and convoluted, is relatively straightforward. We're going from one selection method to another. But that's not really what is at stake here. That's not what is really on the ballot. What is really on the ballot is whether we will have fair and impartial courts or ones that are bought and paid for by billionaire donors. What is really on the ballot is whether the right to access abortion that the state Supreme Court found before will continue to exist or be struck down. What is really on the ballot is whether public school funding that the state Supreme Court was the guarantor of and made sure stayed intact, whether that stays or whether it gets struck down. What is really on the ballot is whether voting rights will be protected by our state constitution or not, whether LGBTQ plus equality will be protected or not, whether transparency and protections for freedom of religion will remain protected or not. That's what's really on the ballot. And you're not going to see any of that in the language on the ballot, no matter how convoluted it may be. And that's why things like this are so important, so that folks get that it's not just about the words that are printed on the ballot. What is left out is more important than what is left in when you go to the ballot box.
So simply speaking, a vote yes changes our system, and a vote no keeps the system.
That's right. A vote yes changes the system and turns our courts into politicized things bought by billionaires. Vote no keeps the opportunity for our courts to be fair and impartial. Keeping fair and impartial courts is important to our state's future. And so I hear from folks from all sorts of life who once they hear about this, are voting no.
Right, right. Well, Martha, I think that's probably about all we need to get at this point. So we appreciate the time to Micah for sharing your thoughts with us on this, and to Trish, who ran into some technical difficulties, I believe. Who knows what happened, but we'll find out. Anyhow, thank you, Micah, for joining us. And again, you're with the Kansas United for Impartial Courts. And
what is your website, Micah?
It's www.kuic.org. kuic.org. And thank you very much for having me.
Yeah.
You're welcome. Pleasure to hear you.
And thanks for the folks here on the internet who have turned in to join us for this. And I hope everybody shares what you've learned from this with your friends, and that everybody's informed when you go into the ballot box, so that you know which way to go. And we'll see you again next time on Heartland Town Hall.